Now at 4, Prince left no last will and testament. Now his family is in court today trying to figure out how to divide up his assets. Dying without a will could cost his heirs plenty.
The death of Prince revealed how important it is to have an estate plan.
It can protect your family fortune, no matter how big or small it may be. And here's how you can get started with your own.
Most people, especially married couples or anybody that has children, should have a will in place.
Attorney David Carlson says the first step in will planning is filling out forms that detail information, such as your family background, names and ages of your children, listing of assets, income, and employment.
That's perhaps the hardest part about the whole estate planning process, is asking the client to provide this information to you.
If you are younger and you do not have any children, a will is preferred but isn't necessary.
If you were willing to allow the laws of the state of Wisconsin to be responsible for distributing your estate. In your case, your estate would be passed first to your parents, nearest next of kin.
Online wills work especially for singles and couples with 1 or 2 children. Carlson says those couples will want something called a testamentary trust. That's a trust created within a last will and testament,
which says when both of us die, our estate will pass to my brother Joe, who will be the trustee for the trust for our children until they turn, say, age 21.
A common misconception is you have to have a large estate to have an estate plan. Carlson says that's not true.
Even people with modest assets should still have an estate plan in place so that their wishes and not the wishes of the state are what follow through at the time of their death.
Prince had a large estate. Carlson says it's surprising he didn't have a trust in place,
which could have avoided all the probably publicity and perhaps a lot of the arguing that's going on here.
Carlson said wills typically take 6 months to a year to distribute unless there are unusual circumstances. Standard costs for talking to an attorney and creating a will range from $600 to $1,000.